Morning, all of you. So, today we are going to discuss the topics public participation and environment impact assessment. In short, we call it as EIA. And this comes under the module 5. We have almost reached the end of the module 5. It's public participation and environment impact assessment. So, what do we mean by the term environment impact assessment? So, environment impact assessment, or in short, we call it as EIA. It is a study to predict the effect of a proposed activity or a project on the environment. So, any developmental activity which we are proposing, it should go through this particular process, that is environment impact assessment. And through this process, we assess the impact, what impact this particular project can cause on the environment, and its legal basis is the Principle 10 of Rio Declaration of 1992, which calls for environmental impact assessment to be undertaken for activities that are likely to have significant adverse impact on the environment. So there is no doubt that any developmental activities which you take, it will have an adverse effect on the environment. So with regard to any such developmental activity, this process has to be carried on in order to understand the kind of impact this particular project is about to cause on the environment. And EIA systematically examines both beneficial and adverse consequences of the project. It's just like a cost benefit analysis. If you are putting in so much of money and other resources, what is the result which we are going to get, and how much it is going to impact the development, the result, which is development, of course, on the one side, and on the other side, how much it is going to impact on the environment. So EIA, it systematically examines both beneficial and adverse consequences of the project and ensures that these effects are taken into account during the project design. And it ensures consideration of environmental implications before making a final decision of assessing the environmental attribute. So if this environment impact assessment shows that yes, this particular project is going to adversely impact the environment to this particular limit or level, then what can be done is you can modify the project proposal and you can make it more environment friendly. And this entire concept of environment impact assessment is based upon the concept of prevention is better than cure. This is almost like, say, for example, why do we wear helmets when we are driving a two-wheeler? Why do we use seat belt? Why it is instructed that you should be using seat belts while driving a car or any other vehicle? So it's a preventive or a precautionary means. Likewise, this also is done. The environment impact assessment is also done as a precautionary measure that it shall not harm the environment beyond a point. So that's the whole idea behind the concept of environment impact assessment. Now let us go a little bit into the historical aspects, like from where this concept has evolved. EIA as a mandatory regulatory procedure, it originated in early 1970s with the implementation of National Environment Policy Act. This is the Environment Protection Act in United States. It is the National Environment Policy Act. In short, it is known as NEPA 1969. A large part of initial development of this EIA took place in countries like Canada, Australia, New Zealand, Colombia, etc. That was the first phase during the 1970s, early 1970s. And in 1989, the World Bank adopted EIA for major development projects in which a borrower country had to undertake an EIA under the bank's supervision. So in 1989, this World Bank, they proposed a suggestion that if at all World Bank needs to give money for any developmental projects, that has to that particular country has to undergo the EIA procedure, and the report has to be submitted to get the amount. And the role of EIA process was formally recognized in the Rio conference, that is in 1992. I was mentioning that in the previous slide also. And principle of the Rio stated that EIA shall be taken as national instrument for proposed projects which might adversely impact environment. So if at all any developmental activity which may adversely if has an impact on the environment, EIA shall be made mandatory. Now let's see the history of EIA in India. In India, first, this process was initiated during the time 1977-78 period with the evaluation of river valley projects. So during that time, whenever a river valley project was commissioned, it has to undergo or undertake this EIA process. This was later expanded to mining industries, thermal power, port and harbors, atomic power, rail and road highways, bridges, airport and communications, etc. So whatever um, the project is, if it is likely to have an adverse impact on the environment, the EIA process was initiated. And the Department of Environment came into existence in 1980s. Before that, the matters related to environment and forest were within the purview of Department of Science and Technology and Agriculture respectively. And the Department of Environment was upgraded to a full-fledged ministry in the year 1985. So the Ministry of Environment and Forest was established in the year 1985, and before that everything related to environment and forest were taken care of by the Department of Science and Technology and Agriculture. EIA functions under the Environment Protection Act. It was also instituted, or it was a notification which was issued by the central government under the Environment Protection Act of 1986. So firstly in 1994, the Ministry of Environment and Forest, they issued a notification on EIA of development projects, and that too under the Environment Protection Act of 1986. And this notification listed 30 projects that required environmental clearance from the central government. And these are the major projects like mining industry, then establishment of a port or a harbor. So such major projects, they have listed 30 such projects which required clearance from the central government. And it also included for the first time public hearing as a prerequisite for clearing large projects. So if public is affected at large with regard to this particular project, say for example, if land has to be taken, so in such situations, public hearing was also considered to be a prerequisite or a condition before getting clearance from the central government. And the notification made it obligatory to prepare and submit an environment impact assessment, and then an environment management plan, as well as a project report to the Ministry of Forest and Environment and Forest, which had the option to consult a multidisciplinary committee of experts. So this notification provided for the procedure to be followed while conducting this EIA. And EIA notification made environmental clearance mandatory for expansion or modernization of any activity or for setting up new projects listed in Schedule 1 of the notification. So if you go through the notification, you can see schedules, and in which you can see Schedule 1, which in which certain types of projects are listed, and this environmental clearance is made mandatory for expansion or modernization of such particular projects which are listed in Schedule 1. And as of now, 12 amendments were made in EIA notification of 1994 since then. So it is actually updated from time to time. So though firstly it was enacted in 94, then it was updated as in when it was required. So there are actually two types of models which are generally used in various countries. One is mandatory model of EIA. That means a legislation is being enacted and the entire EIA procedure functions as per the legislation. And the second category is discretionary model. That is, the entire power is vested with the executive wing of the government, so that the executive can make rules from time to time. And in India, we follow the discretionary model. And let's see what are the steps involved in Indian model. And Indian model is a discretionary model of EIA, which is primarily functioning on the executive orders. So the first stage, there are altogether 8 stages, and the first stage is screening. It determines whether the proposed project requires an EIA, and if it does, then the level of assessment required. So first step is that we should know whether this particular project needs an EIA. If at all it needs an EIA, if at all it needs an environment impact assessment, the level of assessment is also discussed in the first step, that is the screening step. The government rules categorize projects into 2 categories. If you go through the notification, you can see all these things clearly given. The categories A and B, which is based on the extent of the impact, effects on human health and effects on the environment. So all the projects which are proposed, they come under 2 categories, broadly under 2 categories, category A and B. And how this has been classified, it is according to the extent of the impact. So to what extent this particular project may have an impact. It can be either effects on human health or it can be effects on the environment. Category A projects are looked into by the central government and category B goes to the state government. This is how it is. So that means very serious or very the projects which may have serious impact on either human health or on the environment, it is categorized under category A, and these projects are directly undertaken or looked into by the central government. And category B, the lesser evil, it goes to the state government. Category B projects are further subdivided into category B1 and B2. And B1 again, among these categories which falls under B, they again classify it as B1 and B2 according to the impact. And B1 requires a public hearing for EIA, but B2 doesn't require it. Let's see the next stage after screening. That is first step is screening, in which the authorities take a decision whether EIA should be conducted or not. If at all it is to be conducted, what is the extent and limit of that EIA? Second step is scoping. This stage identifies the key issues and impacts that should be further investigated. So after screening, the second stage is known as scoping. And in this stage, they identifies the key issues and impacts that should be further investigated. It's not a single or a very simple process. It has to be done in various steps, and this stage also defines the boundary and time limit of the study. Say, for example, if you are undertaking a particular project, first thing we'll do is whether it causes any impact and should on the environment, and should we conduct EIA. And if they decide that yes, we need to conduct EIA, then the next step is they'll have to find out what all are the key issues. And if at all we need to go on with further studies, further investigation, then what is the scope and limit of that particular study. Now the third stage is impact analysis. At this stage, it identifies and predicts the likely environmental and social impact of the proposed project and evaluates its significance. So then after scoping the limit and all of the study, they actually conduct the study and they analyze the impact. So to what extent it is going to impact, either it can be environmental impact or it can be social impact. And fourth stage is mitigation stage. This step recommends the actions to reduce and avoid potential adverse environmental consequences of development activities. Say, whichever development project we are undertaking, it will definitely have an impact on the environment. So what we can do is mitigate that impact or consequences. So what all things are to be done? The recommendations to reduce and avoid such adverse consequences is being given in the fourth stage, that is mitigation stage. And fifth stage is reporting. Here, this stage presents the results of EIA in a form of a report to the decision making body. So whatever report is being drawn after all the studies and all, and this report is given to the decision making authority as well as interested parties. So all the stakeholders are also being provided with this particular report, study report. After providing with a report to the deciding authority and the interested parties or the stakeholders, the next stage is review of EIA. And at this stage, they examine the adequacy and effectiveness of EIA report and provides the information necessary for decision making. And after review, then the next stage is decision making, actual decision making. It decides whether the project is rejected, approved, or it needs further change. So only three options are left now. Either you accept or approve it, or you reject it, or you can suggest certain changes also. And last stage is post monitoring. This stage comes into play once the project is commissioned. Only after the commissioning of project you can initiate this particular step, that is post monitoring, and it checks to ensure that impacts of the project do not exceed the legal standards and implementation of mitigation measures are in the manner as described in EIA report. It is just a fact checking, like once the project has started, you'll have to see whether it is going on according to the plan, whether it adheres to the legal provisions as well as the report which is given to the authorities. So that is post monitoring stage. This is a simple flow chart which explains which all stages are being passed before giving the final environment impact assessment report. So from the starting, first is site selection, then conduct of EIA, then apply for an NOC, then State Pollution Control Board should arrange a public hearing, and project proponent apply for the environmental clearance or EC, and whatever documents are to be submitted, it has to be submitted along with that. Then it is reviewed by environmental appraisal committee, which may suggest a few changes, and it can accept it as it is or it can even reject. And you can see at the time of EIA itself, when the EIA is conducted itself, they can ask for certain changes. So that is the significance of EIA, environment impact assessment, so that any necessary modifications can be done at the stage of planning itself. So with this, we have already seen that EIA is a decision-making tool, and it compares various alternatives for a project and seeks to identify the one which represents the best combination of economic and environmental costs and benefits. As I told in the beginning itself, it is a cost-benefit analysis basically. So if at all we are putting in so much of money, or if we are compromising with the environment to this particular extent, what will be the benefit we achieve through this particular project? This is what is being assessed through EIA. And it identifies the environmental, social, economic impacts of a project prior to taking a decision on its implementation. It's not just the economic aspects which are important. That's what I want to stress again and again. EIA, it looks into the environmental aspects, then the social aspects. Say, for example, if it is a dam, construction of a dam, then a lot of people has to be displaced uh, due to that developmental activity from that their locality. So it has a social implication also. Then definitely economics is also an important aspect. So this EIA helps to identify the environmental, social, and economic impacts of a project prior to taking a decision on its implementation. And EIA generally would try to answer the following questions. Firstly, what are the potential results of the project? So, say for example, we are planning to initiate a project. What would be the result of this project? And what are the potential changes and extent of those changes? So if at all any changes to be implemented, so to what extent those changes can be made? And thirdly, what can be done about these changes? How can the decision makers have to be informed of these changes? So EIA, while conducting EIA itself, we can understand whether the proposed project is all right, or if if there is any need to change the project, or if that is needed, how it can be implemented. All these things are being discussed during the EIA process. Thus, the EIA becomes a cycle of asking questions and further questions until workable solutions are reached. So, just like we start a small project, what all things are to be? You frame research questions, right, for your projects and all. You firstly write an abstract, then you try to frame research question, you try to identify research problems, and finally, through your project, you give an answer to your research questions. The same process is being carried on with regard to environment impact assessment also. Next, we move on to another topic which is very closely related to environment impact assessment. It is public participation in environmental decision making. What is the role of public in taking a decision which is related to any environmental question? So, public participation can be described as the involvement of all social actors in social and political decision making process that potentially affect the communities in which they live and work. Say, for example, any decision which is taken, being the stakeholder, being an affected party, we should also be given a chance to represent our concern. So, that is public participation in simple words. And public participation in environmental decision making has become an important feature of the environmental regulatory systems. So it is very clearly mentioned in the international documents pertaining to environment protection that public participation is something which is very important. And individuals and organizations affected by development approvals, pollution licenses, land use plans, and other types of regulatory process have increasingly demanded greater consultation and more transparent and accountable decisions. So, whoever is being affected by such large projects, their opinions are also generally sought. Public participation can be done through education. Firstly, people should be knowing what is happening. So they should have awareness. They should get education. Then information dissemination. So what is going to happen with that particular project they are going to implement in that area? So information should be given. Then advisory or review boards. So there is a scope for review. Whatever plan is being proposed, there is always a scope for review, and then public advocacy, public hearings and submissions, and even it can go to the extent of litigation also. That is what is being generally done by all these civil society groups. So all these are examples, or all these are situations wherein you can see public participation is public participation takes place, especially with regard to environmental decision making. The right to participation allows people to be part of the decision making process through consultation and comments, and to have their opinion heard. You might have seen in certain cases, like certain statutes, when they are in the draft stage itself, they are put in the websites of the respective ministries, and public opinion is sought. So, what is that process? That exactly is what we are talking about, public participation. That's just an example of the practical application of this public participation in legislative framework. So it is an interaction between government and civil society, including the process by which government and civil society open dialogue, establish partnerships, share information, and otherwise interact to design, implement, and evaluate development policies, projects, and programs. Participation may enhance the accountability and thus acceptability of the environmental decisions. And we are not ready to accept any decision which is taken without our knowledge, right? So, from the initial stage itself, they seek public opinion, they seek public participation and our comments, especially if we are the stakeholders. So that gives an that itself proves the accountability of the stage, and the project becomes acceptable to the other end also. This may lead to less number of litigations. Obviously, if you are aware of what is going on, we are not going to go for litigations. Then fewer delays and generally better implementation of decisions. So public participation is an essential aspect, especially with regard to environmental decision making. What are the reasons for increase in public participation? There are three important reasons which are put forward. One is increased public awareness and concern about the relationships between ecological health and human well-being. So first, this is specifically with regard to public participation in environmental decision making. Okay, so first is increased public awareness. See, we are more and more aware about what is happening, and we are also concerned about the relationship between ecological health and the human well-being. So right now people are more and more interested in knowing these aspects, and they know actually what is happening. The growth of human rights in legal and political systems has heightened people's expectations of participation in policy making. So right now we know there are international instruments pertaining to human rights which actually gives a chance for the public to participate in policy making. So these awareness has increased our expectations. Thirdly, the prevailing concerns of the international community for good governance and the strengthening of civil societies have contributed to the increasing interest in the use of participatory mechanisms. So, unlike maybe 3 or 4 decades back, we may not be knowing what is happening around us, but right now, due to all the communication, telecommunication, and the social media and all, which has developed very fast, and we are able to understand and appreciate whatever is happening around us. And right now, we are also demanding that our participation should be ensured, because that is something which is very important for good governance. And again, civil societies, the NGOs, they are also very strong these days. So all these has led to the increased participatory mechanisms. And public participation bridges the gap between the heterogeneous groups of the society. There are different categories of people, and if you are also allowed to raise your concerns with regard to a particular public policy, definitely it bridges the gap between the different types of groups in the society. It tries to maintain balance between the right to environment and right to development. Definitely, right to development is important, and it is as important as preserving the environment. So it has to be always balanced approach, and for that, public participation is very important. Now let's see what the International Environmental Law speaks about public participation, from where you can find the roots of this concept of public participation. Like any other concept, we start with Stockholm Conference, though you can't see any direct reference to this aspect of public participation, but it indirectly refers to public participation by talking about equitable sharing of common efforts of citizens, communities, government, and private sectors in order to defend and improve the human environment. So it's not just one category, like citizens alone can't do anything, civil societies alone can't do anything, government alone cannot do anything. So a common effort of all these categories, all these persons, is required to improve the human environment. Then the Nairobi Declaration, that is World Charter for Nature, Principle 23, it has stated that all persons in accordance with their national legislation shall have the opportunity to participate individually or with others in the formulation of decisions of direct concern to their environment, and shall have access means of redress when their environment has suffered damage or degradation. This is one clear principle where you can see public participation is made mandatory. And Principle 16 says that all planning should include, among its essential elements, the formulation of strategies for conservation of nature, etc., and assessments of the effects of nature of proposed policies and activities. All these elements shall be disclosed to the public by appropriate means in time to permit effective consultation and participation. So when you analyze these principles closely, you can say that you can very clearly see that public participation and making the concerned people or the stakeholders know what is going to happen with regard to their environment is very important. And the states are duty bound to involve them while they take any decisions pertaining to the environment. Now, the most fundamental source of this particular concept of public participation you can find in Principle 10 of the Rio Declaration 1992, and it has laid down very clearly environment issues are best handled with the participation of all concerned citizens at the relevant level. It goes on further. At the national level, each individual shall have the appropriate access to information concerning the environment that is held by the public authorities, including information on hazardous materials and activities in their communities, and the opportunity to participate in decision making process. So each individual should have appropriate access to information. That is very, very important. In order to participate in the environmental decision making, first you should have the access to information which is held by the public authorities. Then it says that states shall facilitate and encourage public awareness and participation by making information widely available. So, state is duty bound to encourage public awareness, and that is why they generally give all the details in their websites, etc. Then effective access to judicial and administrative proceedings, including redress and remedy, shall be provided. The state should also provide that if your right to environment is violated, you should be given a chance to redress your remedy. You should be able to approach the court. That also has to be taken care of. Now, let's see how India has addressed this issue of public participation. Public consultation in India, we generally use this phrase public consultation, especially with regard to EIA process and all. We use this public consultation instead of public participation. It refers to the process by which the concerns of the local people regarding the adverse impacts of a project are ascertained and taken into account in the EIA study. Here, the people are given a chance to mention what all are their concerns. They have the right to raise their concerns with regard to a project, proposed project, and that is one important step which we saw in EIA study. And in India, EIA was, yeah, from since 1994 we have this environment impact assessment, but it was only in 97 that for the first time public involvement in the environmental clearance through public hearing mechanism was made mandatory. So in India, this public consultation or public hearing mechanism was initiated under environment impact assessment in the year 1997. And public hearing is a form of participation in which the stakeholders and proponents are brought together in a forum to express their opinions and offer suggestions on a proposed undertaking in order to influence the decision making process. Here, both the parties are brought together. Whoever is involved in this particular project, as well as the persons, the common man who are affected by this particular project, they are put together, brought together, and they are given a chance to express their concerns and opinion, and they can also offer suggestions, and that will definitely positively influence the decision making process. Now let's see a few cases wherein the honorable courts have identified the significance of EIA as well as environmental education or public participation in environmental decision making. So the first case is Center for Social Justice versus Union of India. It is reported in AR 2001, the decision given by Gujarat High Court. In this case, the court has issued following directions related to public participation in environmental decision making. So a few guidelines were set down or directions were given. So how to conduct public participation, how the notice is to be given, where to conduct this public hearing. So all these things, and how many days notice, like 30 days notice is to be given. So these directions were given by the Supreme Court, the High Court of Gujarat in this particular case. And you can see this particular case, it became a standard, or the directions given by the Honorable Court in this case was considered to be having a persuasive effect in the subsequent proceedings. So you can just go through the directions which are given by the Honorable High Court of Gujarat in this particular case with regard to public participation and the process or procedure to be followed while conducting a public hearing with regard to environmental matters. The next case which I'm going to discuss here is MC Mehta versus Union of India, reported in AR 1992 Supreme Court at page 362. This case is with regard to environmental awareness, need for environmental awareness. And it was a public interest litigation. It stressed the need for giving awareness and information related to environmental aspects with a view to educating people about the social obligation in upkeeping the environment and to introduce the environment as a subject for school and college curriculum. So MC Mehta has put forward various suggestions that environmental awareness should be built, and for that the media can be made use of. There can be small short movies and all being telecasted in TVs. Then in theaters they can explain the need for protecting the environment. Then he has asked for the revision of the curriculum, schools as well as colleges, so that environment and pollution aspects are also made a specific subject with special importance to be given. And Supreme Court accepted the prayer, and the court issued directions to give importance to the environmental awareness and education through different mediums. And court accepted almost whatever he has mentioned in his prayer. And environment and its pollution problems should be taught as a compulsory subject. You might be remembering your school days, especially in the primary classes and all. You had this environmental awareness chapters on environmental awareness, like save water. You'll have to protect the natural resources, etc. So all these were the result of this particular judgment. And the Supreme Court stressed the need for introducing a scheme to create awareness about environment protection. So what all things are to be done in order to uh, create awareness in people with regard to environment protection? And also one striking after effect of this case is that the Bar Council of India has introduced environmental law as a compulsory paper for legal education at graduate level. So these are the after effects of MC Mehta versus Union of India in the year 1992. And this specifically speaks about the need to give environmental awareness. So with that, we conclude the topics environment impact assessment as well as the role of public participation in environmental decision making. So we are left with one single topic, that is suggestions for sustainable living, that we'll continue in the next class. And yeah, meanwhile go through all the other materials which has been already given, and do write to me if you have any doubts with regard to any of these topics. Thank you.